Hello, my name is Malik Zain Abbas Awan and I'm a student of University Hertfordshire Law School. My student ID is 2303795. Here's my student ID. Yeah, so the presentation that I'm doing today is includes legal counsel on a case between Hanin and sister makers on the sale of a sewing machine and fabric on a contract basis. Hanin has a tailoring company and brought items which supposedly would be used to grow her business activity. The case poses questions about the breach of contractual duty and obligations under the Sale of Goods Act 1979 and the possible mistakes that the buyer can apply in the case. There are two issues examined in the presentation. The first one is that of the delivery of fabric that was not in line with the contract description and resulted in a skin reaction. The second point is the title of ownership of the sewing machine, since Hanin found out that Knowles Limited had been granted third-party rights over the sewing machine. The English commercial law has clear statutory provisions on the quality of goods, the obligation to deliver goods, and the transfer of title. The legal review thus reviews the rights of Hanin under the Sale of Goods Act of 1979, along with its case law and scholarly commentary. Hanin is a tailoring business and she has chosen to grow her business by acquiring more equipment and materials. Hanin paid a visit to a sewing machine and textile supplier, Sister Makers. Wakar, a sales executive of the Sister Makers, suggested the Sister Maker industrial sewing machine and white silk cloth. Hanin had 50 meters of white silk fabric ordered and asked they were cut into 10 pieces of 5 meters each. Hanin told Wakar that she had dermatitis and inquired whether the clothes would be safe on a sensitive skin. Wakar granted Hanin that the silk would be appropriate. Goods were delivered within a week. The material sent was cream instead of white silk, and it was made in 2 instead of 10 pieces. Another causative outcome of handling the fabric was a rash developed by Hanin. Sister Makers would not take a refund since the fabric was to be cut. Hanin subsequently found out that Knowles Limited had acquired third-party rights to the sewing machine, which brought into question the legality of the seller to sell the machine. The legal regime surrounding the case is mostly based on the Sales of Goods Act 1979, which oversees contracts in the sale of goods between business entities. The applicability of the Act is due to the possibility that the transaction involved a business buying goods in order to use them commercially. Section 13 demands that the goods to be appropriate to their description. The provision secures buyers who will be depending on what the seller told them during the time of the contract. Section 14 subsection 2 demands that goods should be of satisfactory quality. The satisfactory quality is a notion that involves safety, stability, and lack of defects that can render the commodities unusable in normal conditions. Section 14 subsection 3 gives the goods to be fit for the specific purpose that is known to the seller, where the buyer indicates that they rely upon the skill or judgment of the seller. The breach of non-consumer sales contains consequences as stipulated in Section 15A. Section 27 demands the seller deliver goods in line with the contract. Section 30, 32 to 36 regulate delivery and acceptance. Part 38 is about the transfer of property and remedies available. Consumer protection can also be emanated under the Consumer Rights Act 2015, in which the buyer is a consumer. The common law principles also become significant in deciding on conflicts that occur due to the sale of goods. Among the very important principle is the nemo, the principle, which states that no seller can convey to a greater title than that which he held. This regulation safeguards the right of the original owner of items and does not allow the sale of goods to an unauthorized seller in possession of a legitimate owner. This rule is accompanied by the provisions of the Sale of Goods Act 1979, and there are also a number of exceptions that accompany it. These exceptions would be under the situations of sale under a voidable title, estoppel, and sale under the authority of a mercantile agent. In situations where there is commercial certainty and fairness, courts may grant ownership where there is protection of the innocent buyer. The remedies of breach of a contract are also directed by the law of damages. In the Hadley versus Baxendale case, the introduction of the rule that the damages should be capped on the losses that otherwise follow as a natural consequence of the violation of the contract or that are reasonably predictable at the time of contract signing was decided. This interpretation is also backed up by academic commentary. The reason is that commercial law unravels the nature of implied terms, transfer of properties, and remedies of a contract in contemporary commercial dealings. The case on the fabric has a number of implied terms in the Sale of Goods Act 1979. Section 13 demands that goods be in accordance with their description in the contract. Hanin placed the order for white silk, but the materials received were of cream-colored fabric. The goods are thus not in accordance with the contract description. Section 14, subsection 2 demands that the goods should be of satisfactory quality. Satisfactory quality incorporates safety and defect-free quality. Contact with the fabric resulted in the development of a skin rash in Hanin. The response indicates that the goods might be in violation to the statutory provisions of safety. Section 14, subsection 3 demands that the goods should be fit for a given purpose in cases where the buyer informs the seller of that purpose and they depend on the skill or judgment of the seller. Hanin told Waqar that she was having dermatitis. Waqar assured that the fabric would be safe for delicate skin. This is maintained in the case of Griffiths versus Peter Conway Limited 1939, in which the court ruled that the seller is not liable in event of failure by the buyer to disclose a special sensitivity. Of Goods Act 1979 offers a number of remedies in the face of a breach of implied terms by the seller. It is possible that Hanin can refuse the fabric due to violation of sections 13 and 14 by the seller. The Act has provided in sections 35 and 36 that rejection must take place within a reasonable period prior to the buyer being considered to have accepted the goods. An effective rejection allows the buyer to pay back the purchase price. Hanin can also seek damages for the financial loss as a result of the breach. Damages can be compensation for the replacement silk and the price between the contract price and the market price. Hanin would also be able to argue that he has suffered consequential losses due to the breach. In the Headley versus Baxendale case, the court held the damages would be confined to reasonable foreseeable losses incurred during the contracting process. The Consumer Rights Act 2015 would offer equal redress in the case the contract was included in a consumer transaction. According to Downey's 2012, in cases where the quality of goods is below the statutory levels, the consumer can apply repair, replacement, price reduction, or final rejection. The case over the sewing machine is over the legal concept of nemo, that cause non-habit. This principle implies that a seller cannot part with a title that he has in a buyer condition. This rule codified in section 21 subsection 1 of the Sales of Goods Act 1979. Hanin cannot obtain a valid ownership in the event the sister maker was not the owner of the sewing machine or had no power to sell it. There are various exceptions which can permit the passage of title without the owner having ownership of the title. One such exception is that of voidable title. A buyer can obtain a good title whereby the seller had a voidable title which was not rescinded at the moment of sale. The court in Cundy versus Lindsay case ruled that the title would not pass under a contract procured by fraud. In case of Lewis versus Avery, it was acknowledged that a buyer can acquire a good title where the seller already had a voidable title and the contract was not rescinded. There are other exceptions which consist of estoppel and sales carried out by mercantile agents acting as agents of apparent authority. Can be offered to Hanin are based on whether or not sister makers had a valid title in the sewing machine. Hanin cannot retain the machine against the true owner in case System makers did not possess the same, and Knowles Limited has a better title. Alternatively, Hanin can file an action as a breach of contract against system makers. According to Namath and MD Nordin 2023, a buyer can seek restitution of the purchase price and damages when the seller transfers the goods without a valid title. The law is different when the title held by system makers before the sale was actually voidable, which is not rescinded. Hanin should not lose ownership without Knowles Limited demonstrating that it is a bona fide purchase of the property without notice at a fair price. The court in case of Bishopsgate Motor Finance versus Transport Brakes talked of situations in which the title may pass under exceptions of the NEMO that rule. Hanin O to take a look at invoices and ownership documents and determine the presence or absence of security interests or prior ownership rights. Shows that Hanin has solid arguments relating to the fabric provided by system makers. System makers violated sections 13 and 14 of the Sale of Goods Act 1979. In that goods were not fit for the description and they might not have been safe for the use of the buyer had given. Hanin owed to refuse fabric immediately and give a written notice to the seller demanding a refund or replacement. Hanin can also assert damages as a result of the breach of financial losses. The swing machine case involves the case of the chain of ownership that needs to be investigated. Hanin must seek documentary support that system makers had the legal capacity to sell the machine. Hanin can claim damages against system makers in case Knowles Limited is in the position of the superior title. Hanin owe to retain all the records of the transaction and keep track of the contacts with the seller. Hanin should also reduce the losses by making alternative materials or equipment in case of the need. Thank you. That is all from my side. Feel free from my side. Thank you.